South Africa's constitutional watchdog, the Office of the Public Protector, has facing renewed scrutiny following allegations that it failed to act on a serious complaint involving alleged irregular salary payments within the Limpopo Department of Education. A Limpopo-based whistleblower, Maputi Mashalane, has formally accused Public Protector Kholeka Tjaleka of renegating on a commitment to investigate the matter, despite an internal review decision that found the allegations warranted further scrutiny. Mashalane has now escalated the issue to Parliament and the Legal Practice Council, arguing that months have passed without any visible investigation being launched. Allegations linked to Limpopo schools' payments. At the center of the dispute is a complaint concerning Seshego High School in Limpopo. Mashalane alleges that two principals were simultaneously paid salaries at the same school in contravention of the South African Schools Act, resulting in unlawful expenditure of public funds. He submitted documentary evidence and asked that the matter be investigated and that any irregular payments be recovered. The complaint also questioned the conduct of the Special Investigating Unit after the SIU referred the matter to the Department of Public Service and Administration rather than pursuing further action itself. Initial refusal, then reversal on internal review. In May 2025, the Public Protector's Office initially declined to investigate, arguing that the SIU's decision amounted to administrative action that could only be reviewed by a court or tribunal. Mashalane challenged that decision through an internal review process. In a determination dated 24 September 2025, the Public Protector's Office reversed its earlier stance, concluding that the allegations were serious, involved potential financial prejudice to the state, and fell within its jurisdiction. The internal review further indicated that the matter should be allocated to another investigator and that the complainant would be contacted for additional information. Mashalane says he received confirmation of this decision from the Public Protector's Chief Operating Officer, Advocate Nelisiwe Nkabinde. Complaint escalated to Parliament and legal regulators. Despite these assurances, Mashalane says no investigation has materialized. By February 2026, he approached the Parliament of South Africa, lodging a complaint against Tjaleka and raising concerns about what he describes as administrative inaction. He also reported the matter to the Legal Practice Council, alleging professional misconduct. I reported the non-investigation to the Speaker of Parliament, Togo Didiza, Mashalane said. Parliament sought clarity from the Public Protector's Office, which confirmed that the matter would be allocated to another investigator at the National Office. That was in late 2025, yet months later, nothing has happened. Correspondence from Parliament confirms that the complaint was initially closed but reopened through internal review and allocated for investigation. However, Mashalane maintains that no investigative steps have followed. Limits of Parliament's oversight role. The Office on Institutions Supporting Democracy in Parliament advised Mashalane that the National Assembly cannot interfere directly in the operations of the Public Protector due to the institution's constitutional independence. Under Sections 181 and 182 of the Constitution, the Public Protector is empowered to investigate improper conduct in state affairs, report on it, and take remedial action without fear, favor, or prejudice. Parliament's role is limited to oversight and accountability mechanisms rather than direct intervention in specific investigations. Legal Practice Council confirms complaint. The Legal Practice Council has confirmed that it received a complaint against Tjaleka on 24 November 2025. Spokesperson Gabelo Letebele said the allegations relate to an alleged failure by the legal practitioner to conduct herself in accordance with professional standards in a civil matter. The complaint was referred to Tjaleka for a response, but no reply was received. Follow-up correspondence was subsequently sent. The matter is now awaiting placement before an investigating committee, which will consider it on paper in the absence of a response. Once a recommendation is made, both parties will be informed of the outcome and the next steps. The Legal Practice Council also noted that Tjaleka has been on the non-practicing role since November 2006. Broader implications for accountability. The internal review by the Public Protector acknowledged that while the office cannot act as a court reviewing SIU decisions, it does retain the authority to investigate maladministration. It further noted that primary responsibility for the alleged irregular appointments rests with the Limpopo Department of Education, with oversight roles played by National Treasury, the Department of Public Service and Administration, and the Public Service Commission. Crucially, the review concluded that special circumstances existed due to the seriousness of the allegations and the potential financial impact on the state, justifying an investigation by the Public Protector. No response from the Public Protector's office. Attempts to obtain comment from Xaleka's office were unsuccessful. Her spokesperson, Ndilim Soki, did not respond to questions sent to the office. As the matter stands, the case raises broader questions about responsiveness, accountability, and public confidence in Chapter 9 institutions, bodies designed to safeguard democracy and protect the public from maladministration and abuse of power. The outcome of both the Legal Practice Council process and any eventual investigation by the Public Protector will be closely watched.